Okay, we're going to begin. This is legal research legal research in English. Okay, and we're going to video record the lecture. It will be available on YouTube probably 3 weeks after each lecture. Okay. I have taught legal research in English in a different way from the way I'm going to do this semester. You all have your 법률정보조사 textbook, right? Can I take a look? Okay. So you have this. It's not that difficult. You can go through it yourself. In the past, I try to just repeat that in English, and I thought it was very not productive. This semester, I'm going to do it a different way. I realized that once you learn the abstract concept, once you learn the law in one language, then you already have established in you this abstract structure of logical reasoning. So there's really no reason to repeat that in another language. Okay? So you can obtain that abstract structure of thinking just by reading that book. Now, if you want to do legal research in English, what you need is vocabulary, okay, and ability to match what you know in Korean to what you know in English. What dominates English vocabulary in English vocabulary in English, what dominates legal vocabulary in English is American law and American legal concepts. So I'm going to talk about the basic concepts in American law and basic understanding of American law so that you can adapt your research ability in Korean to another language that is English. Okay? So, hope this is not a big surprise to you and you can cope with it at a reasonable pace. All right, so, okay. 잠깐만요. 켜져 있는데. 켜졌다. So, learning American law requires familiarity with the concept sources of law. 이거 아마 여러분 책에 이제 법 1이라고 돼 있을까요? 법 1. So, what are the sources of law in American law? Okay, repeat after me. Cases and statutes. Okay, repeat after me. Cases. Statutes. Okay. You all know what they are. Statutes are made by which branch of the government? Okay, I can give you hints you can choose from. So, legislative, judiciary, and executive. Who makes statutes? Legislative. Okay, who makes cases? Judiciary. What does executive make? Nothing, because they are the executive branch. They execute the law. That's why they are called executive, right? They only enforce and execute the law made by judiciary and made by legislature. Now, which one is higher? Cases and statutes. Which one takes precedence over the other? Anyone? That's good. You don't raise your question. You don't raise your hand because it says it is difficult to say. All right? That is the answer. It is difficult to say. But judiciary. Now, judiciary are limited to interpreting statutes, so they cannot violate the plain meaning. 문헌적 해석이라고 하죠. Plain meaning of the text of statute. But at the same time, who interprets the statutes? The judiciary. Sometimes judiciary can interpret the statute and decide that the statute is void, invalid, right? Under what? I mean, how can a statute made by people's representatives become void? How is that possible? By what standard can a statute become void? Anyone?
Constitution.
Yes. So Constitution is the highest law which legislature cannot change easily. Well, they can change, but they cannot change easily, right? So if the law violates the Constitution, it's called unconstitutional and it becomes void. Now, these cases and statutes, these are called, repeat after me, primary sources of law. There are other than primary source of law. Secondary sources of law. Okay. That's why we have the term primary source of law. So repeat after me. Secondary source of law. Which one do you think are more important? Primary sources, secondary sources? Which one sounds more important? Primary sources. Okay. Case statutes are most important. Now, when I say secondary source of law, these are the interpretations and applications of cases and statutes. They are rules and regulations. By the way, this is already on the blackboard. You can download and you can read it right now if you want to. Okay? You can, if you have a computer, you can live in right now. Executive orders. So they are also statements of law. They are not the law itself. They don't have the force of the law, but they also form the law at a lower level. And ordinances. Ordinance is also a law that's made by local governing bodies. 지자체죠, 지자체. Also treaties. 조약이죠, 조약. Treaties are also considered statutes, depending on what international legal principle the countries follow. I talked about constitution. Now, the way judiciary reviews the validity of the statutes, okay, the procedure by which the judiciary reviews validity of the statute is called judicial review. Repeat after me, judicial review. Main reason why cases are not considered lower or less important than the statutes, because statutes can be struck down as unconstitutional. Okay, one phrase you need to be familiar with. Strike down. Repeat after me. Strike down. The lovers of baseball know what strike is. This is different kind of strike. It means tear it down, right? So strike down means find something unconstitutional, make it void, destroy, right? 그러니까 위헌 판결을 했다라고 할 때 strike down 는 표현을 쓰고요. 합헌 판결을 했다라고 할 때는 uphold. Repeat after me. Uphold. So it is through judicial review that judiciary decides either to uphold or strike down a statute. Now, in legal research in American law, it's very difficult. It's very important to know how to read fast. Okay? So, all right. Why is reading fast important? Because you have to read lots of cases. Why are cases so important in legal research in English? Because it is through cases that much of the interpretation of statutes and interpretation of other statutes is decided. So the main principle by which cases are decided in American law is called stare decisis. I'll get to that later. But because of stare decisis, it is called common law country. Repeat after me, common law. What does common law mean? Common what? Right? What does it mean, common? Common law is sometimes translated as common이니까 commoner라고 하면 이제 사전 찾아보면 보통 사람이라고 나오죠. commoner. 그래서 뭐 보통법이다 뭐 이렇게 번역하기도 하는데 I think this is wrong. Okay? It doesn't capture why American law is called common law. The term common comes from 13th century English king who traveled the country and found judges in different regions deciding on the same cases differently. He thought it was unfair that some people receive different treatment because they live in different parts of the country. So he invited judges from different regions to the capital and have the judges talk to one another. All had judges travel the world, travel the country themselves, so that they try to decide, they try to decide by one body of law, not different bodies of law depending on the region. That's where the term common comes from. He wanted to build law. He wanted to make sure that judge-made law, case law, is common to the entire country, not to small regions. So it is this intense focus on equality that drove English judges and the king to try to decide all the disputes on a commonly shared principle. Commonly shared principle. And the principle that all the cases should be decided on commonly shared principle is called stare decisis. Repeat after me, stare decisis. Stare means stand, 서 있는다 그런 뜻이고, decisis, 결정이란 뜻이고요. 그러니까 과거의 결정에 근거해서 결정한다 그런 뜻이에요. Stare decisis. So when judges decide new disputes, they have to decide according to a body of law composed of past cases. They thought that's the only way that people will be treated equally under the law. Now, in civil law countries, 자, common law 반대말이 뭐예요? 잘 들으면 힌트가 다 있어요. In civil law countries, there is no requirement that new disputes are decided according to precedents. 한국에도 선판례 구속성이 있죠. 선판례 구속성. 근데 한국의 선판례 구속성은 이 stare decisides보다 훨씬 더 약해요. 한국의 선판례 구속성은 대법원 판례, 그러니까 자기보다 상급 법원의 판례를 따르라는 얘기에 그치기 때문에 어떤 법리라기보다는 또는 법 방법론이라기보다는 법률 방법론이라기보다는 법원 조직 이론에 가까운. So the Korean version of stare decisis is not really stare decisis. It's very weak because it only requires judges to follow the higher court's judges' decisions. So it's not really legal methodology. It's only a governing or organizational principle of judges. Or it's just a hierarchy between judges or judges' power. It's not really a legal methodology. Stare decisis is the real thing. Stare decisis binds all the judges. Even Supreme Court judges are bound by their own precedents. That's what stare decisis is. If they decided like 10,000 cases on a certain issue, right? If they decided like 10,000 cases, these are data points. That's the universe of cases. And from these cases, you can draw body of law like this. Then the Supreme Court itself is bound by this body of law. Right? So if something is illegal, right? These 10,000 cases, if you generalize a principle from these 10,000 data points, you get a principle that something becomes illegal only inside the triangle. And if a new case comes up and if it's outside the triangle, is it illegal or legal? Legal. Okay? And even the Supreme Court justices have to decide within that constraint, within that restriction. So, that's why stare decisis is important. Now, let's talk about how stare decisis really works. Repeat after me. Analogous precedents. Again, analogous precedents. 비유가 될 만한 뭐 그런 뜻이에요. 비유가 될 만한, 유비가 될 만한 선례. Okay, compelling precedents. Repeat after me. Compelling precedents. Compelling. 강제력이 있는 그런 뜻이죠. 그래서 선례 내용이 the force of the facts in the previous case is so compelling on the judges deciding the new case. When that happens, it's called a compelling precedent. So legal research in English or legal research in American law, the essence, the most important project within American law research is finding a compelling precedent on a given legal issue. That's why you have to read a lot of cases. Because once you have a compelling precedent, it beats anything else. Okay? It's like Jack in blackjack. It's an ace. Okay? In poker, that's what you're looking for when you are doing legal research in American law. What do I mean by that? Let's talk about real cases. All right. Let's say you are a judge in a traffic court and you received a new case where a car traveled 40 kilometers per hour on a sunny day on a dry road. Now you're a judge in a common law court. You have a fact, right? You have these facts. 그러니까 보통 우리가 사실관계라고 부르는 거죠. 이제 더 어려운 말로 사태라고 부릅니다. 사태. 사실의 양태라고 해서 사태라고도 부르고. So this is the 사실관계 or fact pattern or 사태. Why is it so funny? Given to you. Now you need to make a decision. You're a common law judge. What do? You don't look at your law book. You look at your cases. You go find cases decided on a similar fact. Okay? 도로교통법을 보는 게 아니고 도로교통법을 해석했던 다른 판례들을 보는 거예요. That's considered more important. More important than what the statute says. Okay? So he goes to the library, he does search word, 40 kilometer dry road, sunny day, and then he finds these two cases, these two precedents. In case A, car traveled 40 kilometers per hour, sunny day, dry road, and a judge, another judge, but the same court, okay, judge of the same court decided that, okay, this is safe. And then he also found case B, car doing again 40 kilometers per hour, on a rainy day. Okay, sorry. This is B. This is B. A나 B나 상관없는데 여러분들한테 드린 거에는 또 A로 써놔가지고 헷갈릴까봐. Okay, in case that's case B. On case A, another car did 40 kilometers per hour, sunny day, wet road. 아니다. 자, 다시. 처음부터 다시. 카메라 이거 편집해 주세요. 자. 오케이. 자, 다시. A. So common law judge decides not by the book but by cases. So goes back to the library, sits in front of a computer, does a search, find these two cases. In case A, car doing 40 km per hour on a sunny day on wet road, and another judge of the same court finds that unsafe. And then he finds another case where car did 40 km per hour on a sunny day, dry road, and that was decided to be safe. So these are the cases. 다시. 이게 지금 10번도 넘게 한 건데 자꾸 틀리네. 아니, 처음 틀리네, 처음. Okay. Alright. Again, found case A where a judge of the same court found a car traveling at 40 km per hour on a sunny day, wet road, to be safe. Okay. Found another case, case B, where another judge of the same court found car doing 40 on a sunny day on a dry road to be unsafe. Now, this is the universe of cases given to you. What will be your decision? Anyone? You are the judge. How are you going to decide this new case? Safe or unsafe? Anyone? Yes?
If we take case B as a new case, then I think the judge should follow the case A because the wet road proves to be more dangerous to travel by, and the judge will...
Exactly. Right. Which one presents more danger? Sunny day dry road or sunny day wet road? This is a more dangerous condition, right? And yet, judge found that to be safe, right? That means in this safer condition, doing the same speed should be safe or unsafe? Of course safe, right? There's a term for it when I say of course. Repeat after me. A fortiori. 당연히 그런 뜻이에요. 당연히. 그래서 라틴어 당연이란 말이 나올 정도로 자기 사건에 강제력을 부과하는 케이스. So case A is a compelling precedent. Case B, well, it could be a compelling precedent, but it's not. It's only analogous precedent. Because it is similar to the new case, but it doesn't have compelling power. It doesn't have power that compels a judge on the new case to decide one way or another. So there are a few other phrases that you have to learn. So if it's a compelling precedent, what do you do as a new judge? You have to follow a compelling precedent. Repeat after me, follow. Now, let's say you found an analogous precedent, right? 40, sunny, dry. All right, they are analogous, but it doesn't really push you to decide one way or another, right? Because, it doesn't list all other facts. There can be other hidden facts like amount of traffic, right? It doesn't have the same compulsive power that case A has. So you look at this case and find out that, in case B, there was a lot of traffic. And in my case, not much traffic. Okay, because of the amount of traffic, I will not follow case B. Okay, I'll not follow case B because that is what makes case B different from my case. When that happens, you can say you distinguish. Repeat after me, distinguish. So the life of a legal researcher in American law is follow or distinguish. Follow or distinguish. Read lots of cases and decide what cases to distinguish, what cases to follow. Right? Okay, any questions so far? Yeah.
Just by any chance, if the significant facts are similar, both A and B, but the result, the cases are different, where one will say, but they're both dry, and the past precedences say they are both unsafe, or something like that, then what do you do as a judge?
Well, you have a problem. There are difficult cases. You will have to find a reason to distinguish a certain case and find another case to follow, or find the reason to follow. I mean, usually what you end up doing is, if cases A and B do not produce a legal principle strong enough to decide your case, then you broaden your search. Look for case C, D, E, and F that make up a higher principle and try to apply the higher principle to that case. That's what I showed in this textbook. 여기 법률정보조사 제 5장. 딴 거 딴 부분 읽지 않으셔도 5장은 꼭 읽으시기 바랍니다. 5장은 제가 쓴 거예요. 꼭 읽으셔야 돼요. 네, 나머지는 나머지도 읽으셔야 되는데 나머지는 이렇게 설명서처럼 읽으시면 되는데 5장은 좀 생각을 해보시면서 포섭이 뭐고 해석이 뭔지, 왜 법을 제대로 하려면 해석으로 나아가야 되는지, 포섭으로 끝날 수 있는 법은, 그 수준의 법률은 이 로스쿨이나 법학에서 할 게 아니에요. 그거는 그냥 법률가 아닌 사람들이 그냥 하면 돼요. 사실은 요즘은 사람이 아니라 그냥 컴퓨터가 하면 돼요. 네, 그게 포섭이에요. 근데 포섭되지 않는 수많은 사태들이 있어요. 포섭되지 않는 수많은 사실관계들이 있고, 그 사실관계들을 해석을 통해서 법적 효력을 부여하는 거, 이게 그 해석이라는 작용입니다. 그래서 34쪽 같은 데 보면은 그 2011년도에 공직선거법에 그 선거운동 금지 조항이 있는데, 문서에 의한, 그러니까 선거운동이란 뭐냐라고 했을 때 이제 문서 뭐 이런 것들을 통해서 돼야 된다고 했는데, 그럼 인터넷은 인터넷을 통해 선거운동하면 그 문서냐? 인터넷 여러분들 문서라고 생각해요? 인터넷에 있는 문서? 지금은 보통 그렇게들 생각할 거예요. 왜? 수많은 문서를 지금 인터넷으로 처리하고 있으니까. 그런데도 불구하고 2011년도에 헌법재판소는 인터넷을 통한 선거운동은 문서에 의한 선거운동에 포함 안 된다라고 결정을 내려요. 왜 그럴까? 그 전 판례가 있는데 A나 B 가지고 해결이 안 된 거예요. 다른 판례들을 더 찾아본 거야. 찾아보니까 공직선거법의 입법 목적이 뭐냐. 공직선거의 입법 목적은 금권선거를 막는 거였다. 인터넷에 의한 선거운동은 돈이 드냐? 아니다. 개인이 홈페이지 하나 만들어서 할 수 있는 게 인터넷에 의한 선거운동이다. 그렇기 때문에 조문에는 문서라고 돼 있지만 해석을 입법 목적에 따라 해석을 해보면 인터넷에 의한 선거운동은 적용해서는 안 된다라고 하면서 위헌 결정을 내리죠. 네, 그게 이제 해석의 중요성이에요. 오케이. 그리고 잠깐만 다시 봅시다. (5장) 말고 (8장도) 꼭 읽어보시기 바랍니다. 그것도 제가 썼어요. 네. 이거는 여러분들이 그 관심을 가져야 될 변호사 정원제의 위헌 내지는 합헌을 다투는데, 역시 주어진 케이스들로는 변호사 정원제가 위헌인지 합헌인지 결정을 할 수가 없어요. 그러면은 딱 비슷한 사건은 아니지만 조금 더 가까운 사건들을 C, D, E를 더 찾고, 그러다 보면은 외국 판례도 찾는 거예요. 그럼 외국 판례도 찾아서 그 판례들로부터 어떤 원칙을 도출해서 그 도출된 원칙을 적용하는 그 과정을 8장에서 보여주고 있어요. 자, 원래 50분에 마쳐야죠? 예, 50분 됐고 마치겠습니다. 그러면 다음 시간에는 제가 드린 블랙보드에 올린 거에 보면 Introduction to Civil Procedure라고 있어요. Introduction to Civil Procedure. 민사소송법. 그 파워포인트를 꼭 읽어보시기 바랍니다. 그리고 First Lecture라고, First Segment라고 올려져 있는 게 있어요. 그게 오늘 제가 강의한 거 영어로 적어드린 거예요. 예, 마치겠습니다. 수고했습니다.